I'm Scott Sagan, professor of political science and co-director here at the Center for International Security and Cooperation. And it's a real pleasure to have Deborah Pearlstein with us today. She's a professor of law and the co-director of the Center for Constitutional Democracy at the Cardozo Law School at Yeshiva University. She's written for many different law reviews in her career, but I think other people will know her from publishing in the Atlantic, Foreign Policy, Washington Post, and New York Times. She'll be talking off of a paper that's going to be coming out with the Georgetown Law Review called Lawyering the Presidency, the Legal Counsel and Constraints on the Use of Force. So Deborah, I'll turn it over to you. We'll go for half an hour, a bit more if you want. I'm asking everyone who's attending, if you have a question, put it into the Q&A and I'll be able to monitor that. And if my ability to do this does work out, I'll be able to actually unmute you so that you can ask your own question, and I'll call on people after Deborah's done, okay? Deborah, over to you. Thank you for joining us.
Thank you. I'm delighted to be here, and thanks especially to Scott for the invitation and to Emily for help with all the logistics. I much more frequently speak to legal audiences, but I'm really thrilled for the opportunity to talk about this work with this audience because it certainly crosses boundaries, as I might say. I want to see if I can go ahead and share some slides with you. And I will confess at the outset that PowerPoint and the like are not my strong suit, but let's see if I can do that. Scott, are you able to see slides? Oh, you're muted.
Yes, we can see the slides.
You can see a slide. Okay, so I'm going to try. Now I just
hit on the slideshow and it'll start.
This is what we should have done in advance. Now I just need to be able to see them myself. Okay, here we go. I think I got it now. So my paper, as Scott mentioned, is called Lawyering the Presidency, Legal Counsel and Constraints on the Use of Force. And I want to start just by putting this in a little bit of context. Obviously, during the Trump era, and as a professor of constitutional law, one of the most, I viewed it as a professional hazard, one of the questions I had most frequently, almost every day, from students or colleagues or members of the press or folks on the Hill was some version of, can the president actually do that? And perhaps none of those questions were more consequential than, of course, questions that arose regarding the president's use of force and ability to use force. And here is the slide of the famous, I'm sure you're all familiar with, quotation about fire and fury and the use of force against North Korea. And the questions in this context went, can the president, isn't there some law that prevents the president from waking up one morning and deciding to start a war with North Korea? And without, although I'm happy to talk about the legal rules about that in the Q&A later, without getting into the substance now, right, that particular question is just a particular species of a much longer and more long-standing question that extends well beyond the nuclear context and typically phrased in sort of realist terms in international relations. It's the question about whether law can really constrain high power, and particularly state use of force. So my project in this particular paper at its broadest is really about trying to shed some light on that question by looking at one of the key mechanisms by which law operates at the presidential level, and that is through the guidance and instruction of presidential legal counsel. So by presidential legal counsel, I mean not just lawyers in the Department of Justice Office of Legal Counsel, with which you may be familiar, but also, of course, White House counsel's office, and especially as well, the general counsels who exist in key agencies, not only at the National Security Council, but also in the Department of Defense, the Department of State, in the DNI's office, in the intelligence community, obviously, and others. And the question that I was really asking here was whether non-military policymakers actually consult with and attend to counsel's advice on legal rules regarding the recourse to force. So the sort of most fundamental first order use of force questions that we encounter. And if they do, why does that mechanism work, and to what effect does it function? So as I point out just here on this next slide, right, in the current context, obviously this question became acute for a lot of political scientists and policymakers and others during the Trump years, but concerns about the role of legal counsel and its ability and its effectiveness in constraining, applying legal rules to constrain the use of force by the executive certainly predate the Trump administration. Just in the last 20 years, here are some of the most well-known examples. Obviously, during the Bush administration, the Office of Legal Counsel interpreted the Constitution, among other things, to prohibit the application of federal criminal laws prohibiting torture of detainees to the president on the ground that it would be an unconstitutional infringement on presidential authority. That criticized, I think quite rightly, as an unethical use of lawyering and legal advice. But during the Obama administration as well, in interpreting the scope of the congressional authorization for the use of military force, and in other contexts, international law contexts as well, strong criticisms that, if not unethical, the advice of counsel, the public advice of counsel, at least that the public was aware of in this administration, really adopted sort of the maximally expansive, indeed almost implausibly expansive interpretations of the scope of executive power. And today, lawyers, people who formerly served in these offices, senior legal counsel position, are really divided among themselves about how they should conceive of and understand the role of legal counsel in this context, whether they should simply provide policymakers their best view of the law under all the circumstances, or whether they should aim to maximize policymaker flexibility in all circumstances. So today, if you look, you will find multiple reform proposals from various sort of NGOs, constituencies, think tanks, and indeed congressional hearings on the question of how we should, if at all, reform the role of presidential legal advising.
So I'm going to suggest that you click on the from current slide on your slideshow in the upper left, because people can see all the notes on multiple slides rather than just the one that you're talking off of.
Yeah, I see that, and this is where my
It's not doing
lack of technical expertise comes in. But let me see if I can, because when
I
do that, it seems
it's the second one on the left said from current slide.
Yeah, so I'm gonna do a little setup here so I can see it myself, because I want to be able to see if I can do that, and then from current slide. Okay, does that help?
That helps. It's much bigger.
Okay. Now. Okay, wonderful. Thank you. Okay, so before I go to, so let me just say a word or two more, and this is all by way of sort of introduction, and I'll tell you what I'm planning to do in my remarks here. Before deciding, I think, whether these reforms in this current reform debate make any sense, it seemed to me essential to have a better answer to the question of this more fundamental question of whether, when, and why counsel affect policy decisions at all. So to start to get a handle on that, I decided for the first time, because I am a lawyer and do legal analysis and legal theory, that I would do a qualitative study. I decided, shocked by the fact that this didn't seem to have been done before, that I would ask a bunch of very senior national security policymaking officials. And by very senior, I mean cabinet secretary level. So sort of, if you think about the NSC Principals Committee, Deputies Committee, just down to the undersecretary level at the relevant agencies. So cabinet secretary level at the most senior, National Security Council senior directors at the most junior in this pool. whether and to what extent they felt an obligation to consult with counsel when they carried out those consultations, and to what effect. And to preview some of the conclusions I want to share here, although the paper is a long damn law review paper, so you can find it online to be sure, and I'm happy to talk about any aspects of it. I just want to, for these purposes, highlight just a couple of things that I found. First, on the actual sort of realist skepticism about whether counsel matter at all and anybody pays any attention to them in any sort of real or meaningful way, and I'll talk about what I mean by that, I actually think the answer is clear. Policymakers that I spoke to in the course of this study, which included about 36 folks at this level who served between 2001 and 2017 in the Bush and Obama administrations, more than 36, I should say, they shared across the board a deeply internalized sense of an obligation to engage legal counsel in use of force decision-making. And this was true across political parties and across legal fields. In other words, whether the law that was implicated was US domestic federal statute passed by Congress, or the US constitutional restrictions, or international legal restrictions regarding recourse to force. And especially in areas, and I can talk about this more as well, in which it became clear that policymakers' independent knowledge of what the law in these fields might require was modest, lawyers were capable of having a remarkably influential effect, including their ability to, and in fact, I think evidence of, serving as a constraint on officials' use of force. That is, not pursuing use of force that they might otherwise have decided to pursue. At the same time, though, I want to caution and will that counsel's influence, while unquestionably, I think, significant, and more significant than I would have imagined, it's multi-directional. In other words, it is capable of having a constraining effect, as that term is typically used, but it is also capable, I think, of having important permissive effects, and not just in the sort of extreme John Yoo context that I mentioned at the outset, but in more subtle ways as well. And I'll talk about those as we go. So let me just give a brief roadmap. I'm gonna condense 400 years worth of theoretical and empirical literature on this topic to about 3 slides. So I'll give you just a little bit of grounding in the sort of existing literature on this topic. I'll talk a little bit about how I decided to design my study with a view to trying to avoid some of the mistakes that I perceive, or gaps that I perceive in the existing literature. I'll go into a little bit more detail about some of the key findings and why I think my qualitative study provides some evidence in that direction, and then talk a little bit about some implications for reform. So okay, so right, the theory of everything over the last 400 years about law's ability to constrain power. So here, let me start with the theoretical literature and say, as some of you may know, there is just this very rich and deep theoretical literature in the IR field, in political science, that have various theories, and I'm happy to talk about those at length. But for present purposes, I'm going to pick illustrations of these theoretical examples from the legal literature and folks that have made these arguments, or versions of these arguments, more recently in this context. So you can find in legal literature versions of and here I really do want to be able to see my slides so I can see what I quoted. How do I make this smaller? Sorry for interrupting myself once again. So you can find in the examples of legal literature, there we go. Nope, I skipped ahead. Sorry. No, now I'm going backwards. Sorry. Here we go. You can find in legal literature examples of what I might describe as a realist view about the potential for counsel's influence, and what I might describe as something like a more institutionalist view. So the realist view, the skeptic's view, is captured by, among others, Bruce Ackerman. He's a Yale legal scholar, who says, look, The only thing that you can rely on presidential lawyers to do is to ratify or otherwise approve whatever the pre-existing dispositions of the policymakers are. And you can see one of his quotes there, that in the absence of any serious congressional oversight in this space, and in the absence of any serious judicial review, courts typically treat questions about the use of force as political questions that they won't opine upon. And any meaningful sort of personal sanction that might attach to policymakers who get the law wrong here, lawyers just really come up with and or consulted for the purpose of coming up with some post hoc fig leaf to justify existing policymaker predispositions, and especially given the legal indeterminacy that exists in this field, will pick the interpretation most in line with the executive's own normative preferences. So that's sort of one view, the legal version of realism in IR. Another view says, and this has become much more common, so Jack Goldsmith, who's a legal scholar at Harvard and served as the head of the Office of Legal Counsel during the Bush administration, wrote one book before his service in the administration and wrote a very different book after his service in the administration. And the post-service book says things like, never before has the commander-in-chief been so influenced and so constrained by law. And here the arguments are to the effect that lawyers can't just tell the president and his closest advisors whatever they want to hear. They are bound by their own professional ethical obligations and professional norms of conduct that lead them and give them enormous incentives to at least provide, at a minimum, ethical legal advice. So when you see cases like John Yoo, that's the exception rather than the rule, and they are quite capable, certainly where the law is clear, of acting as meaningful and effective constraints on power. So in addition to being sort of inconclusive in the sense that you have these competing views still available in the theoretical literature, much of this literature is based on, is not only sort of subject to serious critiques of cherry picking of examples to support one or another views, but is also based heavily on this sort of outcome-driven assessment of whether law has constrained. So just to take an example, right, the president, in this case, President Obama, uses military force in Libya without first seeking congressional authorization in 2011. The critical view of this is that this is a great illustration of how the law doesn't constrain the exercise of presidential power at all in this space. One would imagine that the Constitution requires congressional authorization before some major use of military force abroad. The president didn't seek it here, therefore was not in compliance with the law, and therefore this is an illustration that the law and anything that follows from the law, whatever might constrain the law, lawyers or anybody else, are in fact quite weak in this space. But note, of course, that these outcome-based judgments, right, did we use military force or not, are incredibly indeterminate, both about law's effect or especially lawyers' ability to constrain power. It's impossible to tell just knowing what we did, that is use force or not, whether the result was because the president doesn't care what the law says and the law doesn't matter in this universe, whether because counsel gave the president bad advice about what the law requires in this universe, or whether because constitutional law is in fact quite a bit more permissive than the sort of contemporary expectation matters. And again, I'm happy to talk about where the law actually sits on these questions, but I'm going to set all those questions aside for right now, right? So they leave a lot unanswered about the meat and potatoes of how this is actually working. So another body of scholarship is what I would call Largen Empiricals, right? And these studies, and there are a lot in the sort of political science literature, international relations literature. These are just a few examples. If folks want to look them up on my paper sites, lots more, and I can give you others as well, right? These are studies like what I would call treaty ratification compliance studies, for example, right? So the notion is here, what happens? Can we see evidence of treaties and treaty law binding states or changing state behavior from the time they ratify the treaty, for example, to some later time in which they are complying or not with some provision that the treaty requires? And these studies, many of them have been critiqued quite a bit, and I think rightly, for enormous selection effect problems, right? Once a state signs on to a treaty, isn't that some indication already that they're prepared to or may already be in compliance with the treaty's terms? But the other thing, or another problem with this literature, is that it typically doesn't distinguish between legal rules, normative rules, and legal structures, so ways in which those rules might be enforced. So to take a super quick detour into jurisprudence and legal theories of how the law works, right? HLA Hart, H-A-R-T, so this is why I use the word Hartian. HLA Hart famously, and for lawyers' purposes or legal scholars' purposes, conclusively, more or less, explained in 1961 that mature legal systems function as a combination of two things. One are primary rules of conduct, what you can actually do or not do. Thou shalt not murder. They are, for example, on the slide, is a primary rule of conduct out of the UN Charter, which is treaty. And I say which is a treaty, and part of me wants to smile or laugh when I say that, but in fact, that is not as widely known as one might think. But so that is an example of a primary rule of conduct. Hart says legal systems operate both on primary rules of conduct and secondary structures that exist to resolve indeterminacies in the law, interpret the law's meaning, figure out how it applies, resolve disputes that might arise under it, right? So Hart would say these are primary rules and secondary rules. Legal systems require both. And these studies, these big N studies, right, for a long time, political scientists in these studies talked about legal institutions writ large without reference to whether they were talking about actual treaties or whether they were talking about a particular court, an international court, a domestic court, or anything else, right? So limited things one can tell. Much more recently, and this is where I start to come in, there have been some qualitative empirics. So here are, again, are a few examples. These have looked at the role of lawyers. What do lawyers actually do? What effect do they actually have in advice provision? These are small qualitative studies where lawyers are interviewed, JAG lawyers about it, the rules of conduct that govern the conduct of war on the field, and then in Hathaway's most recent paper about the role of OLC, legal counsel in the Department of Justice. And these shed a lot of light for reasons we can talk about, but they also have weaknesses. One giant weakness is they all talk to lawyers. So if one's interest is in wanting to understand why a policymaker would care what a lawyer says, right, one worries that this isn't quite the right audience and that one might be getting somewhat skewed view about the relative importance of lawyers in this field. And they also don't resolve this enormously difficult question of constraint. Are we trying to figure out whether when we say we're looking for evidence of law's constraint, are we looking for a particular substantive outcome, a demonstration that a legal process held the president to a narrower rather than broader interpretation of the law? Are we just looking for evidence that the law is capable of being the dispositive factor in a policymaker's decision, which is a tough thing to prove given demonstrating a single causation factor for anything in this complex space, I think is a difficult challenge, right? So these were some of the weaknesses I was worried about in the existing literature that led me to design the small qualitative study that I did, right? So here's what mine looked like. To avoid the just talking to lawyer bias, right, I wanted to find an elite pool of non-lawyer policy officials. And I described broadly who these were, right? They served in the Bush and Obama administrations, cabinet secretary at the most senior, NSC senior director at the most junior, and their counterparts down to the undersecretary level at agencies in a few agencies, right, in the relevant agencies, the Department of Defense, Department of State, and so forth. And if I looked at that entire pool of people across two administrations, right, that amounted to about 163 people total, right? So already we're in a space where this is not going to be a quantitative study, and I am not going to pretend to make any statistically meaningful claims at all. This really is a qualitative study, and my findings are descriptive. But I wanted to talk about the people who are most likely to have been involved in use of force decision-making. And as we'll see, the respondents were, just statistically, the respondents I spoke to cumulatively reported having participated in decisions involving the potential or actual use of military force on 154 different occasions. So that's a lot, right? Okay, so that was one thing I did. Then to avoid the cherry picking problem that some of these earlier studies had, I wanted to maximize representativeness. And I did that, and the paper describes how I tried to do this. But primarily, I was worried about partisanship, right? Maximizing the number of both Democrats and Republicans, and not only actual party affiliation, but to reflect the range of views within particular parties. In the Bush administration, for example, you can think about different members of the Bush administration and as having actually quite different views on these questions. So I wanted to minimize the danger that I was getting skewed views, right? So I eliminated anybody whose job title was lawyer, even if they were involved in decision making all the time. And I eliminated people who were currently serving, and I went to pretty significant lengths and had to go through an IRB to abide by confidentiality requirements, so that I could tell their subjects, right, the subjects, that this is really your identity will not be disclosed. And participants were given a choice of participating in a completely anonymous digital online study, right? So all I have are sort of what their responses were on this digital study, or oral interviews. And some participated in one or the other, and a few participated in both. Then, to avoid ambiguity about this problem of what do we mean when we say constraint, I wanted to assess influence rather than constraint. So I wanted to ask Hart's question, that is, whether officials had a sense of an obligation, right, that they had to consult counsel in a meaningful time and in a meaningful way, and in a way that might be capable of changing their course of action before the use of force, and or whether counsel was capable of shaping officials' normative preferences or moving officials off some pre-existing normative preference about what they believed in this space. And then finally, to avoid the problem about distinguishing between what's the primary rule or some other normative influence that's acting, right? Do I want to go to Congress because I think it's the right thing to do, or it's a morally good thing to do, or it's a politically wise thing to do? Or am I doing it because my lawyer told me to, right? So to distinguish what kind of influence we're seeing here, I asked two sets of questions. So one set of questions were direct questions that were designed to get at this, when are you consulting counsel, and counsel's operational role that I've talked about. And another set of questions were just designed to get at their sort of normative predispositions in this space. So to do that, I had a set of hypotheticals, 21 different, very short, and these are two different ones, right? Hypothetical scenarios, very bare bones, about different kinds of use of force questions that implicated either a question of federal statutory law, federal constitutional law, or UN charter law regulating, international law regulating the use of force. So here are some of the examples, right, that we're trying to get at some of those questions. And after each scenario, I told them they were senior advisors to the president, roughly. After each scenario, I asked the same three questions. Do you believe that the administration should, all things considered, notify Congress? Do you believe that they should seek congressional authorization? Or do you believe that they should seek UN Security Council authorization with respect to the use of force? Okay, so that was the way I designed the study. And as I mentioned before, gigantic caveats here, right? This is a small qualitative study. Between the online survey and the in-person interviews, I talked to 38 separate people, or talked to or engaged 38 separate people, 16 identified Democrats, 12 identified Republicans, 5 identified independents, and 5 who declined to disclose their political association. So it is small. On the other hand, as we will see, this is a very senior population of people. And even just based on the interviews, I felt actually pretty comfortable that I had done about as well as I could have with respect to representativeness of views across these administrations. Another caveat, right? Administrations vary. There were variations not just between these administrations, but of course, we are now living in a post-Trump world. And there is a gigantic question we need to consider about the extent to which these findings still hold true. And so I think I'll leave it there. There are a bunch of open questions that I'll cite in the study as well. So let's talk about the findings. here's Hart's definition, right, of what I was asking about. Do you have an internal sense of an obligation to engage a secondary structure? The sense that the general demand for conformity is insistent and the social pressure to comply is really strong. Of 38 people that I asked, one answered this question, and here's the most direct way I asked this question, right? This is question number 101, right? Just the straight up, did you have the sense that you should know or seek the views of government legal counsel? All but one said yes. So that's one indication, right? Then I asked a bunch of questions that were designed to get at whether these consultations were at a meaningful time, right? Had you already made all the major policy decisions, or was this, sort of a post hoc, consultation? And all of the people I spoke to in oral interviews, both online responses made this clear, I think, in limited ways. And then the oral interviews really clarified it. These were not just, as they put it, offline consultations. Consultations with lawyers were constant and were at every level. So from the lowest agency level up through the interagency process, all the way to the White House, lawyers were in key rooms. And that the sort of quote at the top of the slide was from one of the interview participants, a very senior policy official, who said, look, my rule was just, you're never in the Situation Room without a lawyer. And there's the famous photograph, of course, of the Obama raid. This is not the famous photograph. This is one of the planning meetings for the Obama raid. And you can see the woman who's right next to the guy in the light blue shirt. That's Mary DeRosa. She's NSC General Counsel, right? So I was enormously persuaded from these sort of conversations that in both administrations, the presence of lawyers in the room was pervasive. Now, there was one person who in oral interviews, a member of the Bush administration, said, look, lawyers can have their views, but when it comes to questions about congressional or UN Security Council authorization, those are ultimately political decisions, right? Now, that was just one person. I think it's important to note the existence of that view, right? Because it may be held by quite a few more than one people. But even the people who expressed skepticism about whether mere presence translated to actual influence, when I later asked the people who self-consciously characterize lawyers' influences, well, in some spaces, yes, or minimal, or sort of only in certain ways. When I asked them later separately whether they had ever had the experience of a lawyer telling them no, and then they didn't do it, they immediately said, oh, sure, all the time. Right. So that was the tenor of the conversations. And I want to make sure to convey that. But what about this more sort of consequential question about influence against normative preferences, right? So they're in every room and they're consulted before policy conclusions have been arrived at. And I can talk about reasons why lawyers end up having this much effect a bit later, maybe. But I can measure sort of real effect in a couple of ways. Let me highlight just a few pieces of evidence here, right? So when I asked them directly whether they had ever either been told no by a lawyer, and this is both in the digital survey and in oral interviews, or whether they had ever been surprised by legal counsel's advice. In other words, whether they're asking questions to which they don't already know the answer, right? Half of all respondents said they had either heard no quite a bit or at all, right, or had been surprised by legal counsel's guidance. And I'll talk about the sort of limits of how often you would expect to find that at this level once things have been lawyered all the way through the agency level up to the White House, right? You might expect to find that not very often, but even at this level, right, you find it among half of respondents. And then I think the most powerful concrete illustration of this was in speaking with members of the Obama administration who had been participating in the president's decision-making about the use of force in Syria pre-rise of ISIS, right? So this is after Syria has exploded with the rise of the Arab Spring, and the situation is deteriorating, and there are refugee outflows and enormous crises there, and a great deal of pressure for the United States to use military action. I didn't ever ask anybody about what did you say or what did you decide in this context and why, but 4 separate interview respondents who had all been in meetings with the president said independently, volunteered that in their view, the key reason, or one of the key reasons why the president was unprepared to use force in Syria pre-ISIS was he the lawyers couldn't give him an argument that it was legal, either as a matter of US law absent congressional authorization, or more importantly, some of them suggested as a matter of international law. So as a sort of concrete illustration, right, that 4 of these very senior people think that's what made the difference seems to me like pretty persuasive evidence. So we can talk more about the details there. But having said all that, with this evidence of sort of significance of counsel's engagement and actual evidence of what sort of a conventional view of constraint might be, I want to immediately start talking about why I don't want to draw too much about the implications of legal constraint from these particular findings. And to do that, since I'm on the Syria example, let me just use one other example from the Syria context. So while 4 of these people who had been in the meetings with the president volunteered the view that the law made the difference here, a 5th said, in conversation about, what effect law might have had here, he said, I don't know if I would call it legal constraint or not. He said, in sort of wondering, because he hadn't fully decided for himself whether the law was really more of what he called an off-ramp for Obama, right? I wonder whether it was really just a way of an excuse that Obama used, a politically palatable justification for not having to do something he didn't think would be effective or he otherwise didn't want to do for policy reasons otherwise, right? And I highlight this particular interview for 2 reasons. One is to show how hard it is empirically to untangle complex causation, right? This is 5 different views of one person's thinking, and multiply this across the entire policymaking apparatus, right? But the other thing is to emphasize that what lawyers say and don't say might make the availability of off-ramps in particular cases or not impossible. In other words, if a lawyer's view of their role is to maximize flexibility for policymakers in all circumstances, and there is an available legal interpretation that says you could do this, right, as there often is in areas where the law is indeterminate, the president might not ever hear the argument. Actually, there's a pretty strong argument that you can't do this, and here's what it is. So that's one way in which, right, counsel's role and the nature of counsel's influence might depend a lot on how we regulate what counsel does. An analogous example of this might be found in President Bush's decision to use force, obviously, in Iraq in 2003. There, President Bush decided to seek congressional authorization before using force in Iraq in 2003, notwithstanding the fact that his lawyers in OLC and otherwise had advised him that no congressional authorization for the war in Iraq was required as a matter of law. Now, it is possible that some decision makers, like President Bush, might on occasion decide, well, my lawyer tells me I don't have to do this. I'm going to do it anyway, just to be on the safe side, right? In this case, the arguments were Bush was entirely persuaded that both it was the morally right thing to do and it would win him political allies, both in the United States and abroad, if he did this. So he thought it was essential. But in many other circumstances, one might imagine, and we can talk about sort of cognitive biases and so forth, when in the thick of decision making, one of the last people you hear from is your lawyer, and your lawyer says, the law poses no obstacle, this is fine. Whether that might in fact might make it as the last available word, more likely that the decision maker will favor a permissive understanding of the law than not. And indeed, while many of these effects are subtle, of course, we have seen, at least anecdotally, these examples I mentioned in the last 20 years of lawyers not just pursuing sort of most flexible, maximize flexibility, but pursuing legal interpretations that are in fact only barely plausible. So this brings me to the question of what kinds of constraints do reformers really want? Why do we care about constraint and our implications for reform, right? So let's assume for present purposes, and you can tell me, right, that one of the reasons we worry, or that some of the reasons we worry about law's ability to constrain in this space is both to ensure that policymakers have full knowledge of the consequences of the options that they might be considering pursuing, including potential legal blowback, whatever form that blowback ends up taking, right? That we want policymakers to be fully informed of legal consequences. And we want to make sure that the laws that are that exist to regulate the use of force, that is, that limit presidential power to use force, whether those are domestic laws or international laws, actually are deployed and capable of being used to their full effect, right? It should be hard for the president to wake up one morning and decide to start a war with North Korea, for example, right? If those are your views about the worry of constraint, I think from my study and sort of thinking about this, 3 recommendations flow, right? Instead of what lawyers currently do, which is fight over whether we should give our own singular best view of what the law requires in this space, or as some have suggested, whether we should give the president what we think is, any legally available course of action in the service of maximizing policymaker flexibility. Both of those views risk favoring expansive interpretations of executive authority, but will not disclose necessarily the unavailability of potentially politically more palatable outs from a course of conduct that policymakers don't want to pursue. Secondly, because lawyers have such remarkable legal influence, and policymakers are not, in fact, all that well informed. I'll give just one example, right? Of the 16 individual subjects I interviewed personally, so I know who they were, right? And we talked about the UN in different ways, sort of when you should go to the UN Security Council for authorization for the use of force. And there is huge agreement among lawyers about the sort of highest level structure there, what Article 2 says, and that there are some exceptions to that rule, right? I do say that 4 of those 16 had any understanding of what that baseline UN charter structure was. Indeed, one official said, I can't recall having seen it written down that there's any requirement ever to go to the UN Security Council for any purpose, right? There is serious legal lack of fluency among policymakers here, and we can talk about why that might be, but it absolutely maximizes the influence of lawyers in this space, right? And when lawyers are otherwise subject to essentially no external check, no external judicial review, or rare congressional engagement, it would improve the service that lawyers do to improve policymaker knowledge, at least a baseline level of knowledge of the operative laws in this space, right? It would be a first line check against lawyers that are acting in a sort of purely off the wall kind of way. And then finally, in response to some sort of reform calls that have called for making counsel more independent from the policymakers they serve. So moving White House counsel down to the Department of Justice in a separate building, making the legal advising structure more formal, more structured. One of the things I found about why lawyers were able to be so influential, in addition to their deep integration of the system, into the system at every level, right, which gives policymakers the sense that they are, as many said, a member of the team. They're on the same team. I can go down the hall and ask my lawyer, and well, my lawyer is a friend. My lawyer is somebody I respect. He or she is really smart. I trust them. Those are among the reasons why they're so influential, along with unchallenged expertise. If we remove that sort of relational lawyering model, we risk minimizing legal influence to the extent of no influence at all. In other words, if we make it too formalized or too distant, we might create a circumstance in which the policymaker is unwilling or less willing to seek legal advice than they clearly already are. So I think having gotten through a lot of ground in what felt like a short period of time, I can keep talking, but Scott, maybe let me pause there and ask whether now's a good time to pause for questions or discussion.
I think this would be a very good point, and I'd like to start with, because I have a few questions for you, and then our policy is often to ask the fellows who are in attendance to ask other questions. I'm going to ask you to the audience members, whether you're a CSEC fellow or not, if you could put your question into the Q&A, I'll be able to more effectively call on individuals. But we have not just CSAC fellows, we have former congressional staffers, we have some arms control negotiators, we have a former university president, we have all sorts of people on this call today. So you'll expect a range of questions, but I have two to start with.
Great.
One is very broad, which is, although the survey and the study is focusing on decisions to use force, during the interviews in particular, I think that people might have mentioned questions or interpretations of the law about what kind of force to use, the use in bello as opposed to use ad bellum questions. Bush had to make decisions about using nuclear weapons, for example, against Tora Bora, or he famously said that all options are on the table against Iran over the nuclear program. And when asked, does that include nuclear options? He said, I said, all options are on the table. Well, President Obama had to make decisions in the Osama bin Laden raid. Do we prioritize kill or capture? And I would have thought that you'd want some legal advice on that. Did people in your interviews talk about those kinds of use in bello questions? And what insights did you have about the way that that framed or constrained or were permissive in presidential decision-making?
Sure. So I guess a variety of things to say, right? First, I should say my study was designed to look at recourse to force questions, right? So it wasn't designed to get at that stuff. And I never raised it explicitly, but I certainly, it certainly came up in a couple of ways in conversations, which I'll mention. And I should also add, in addition to the population of policymakers, I also talked to the legal counsel who were participating in these decisions in different periods of time in different administrations. So I have some sense of what they say. And of course, they've been writing about that as well, how they describe their own involvement and what questions arose. So let me give maybe one example that was particularly interesting of when that came up, and especially in the Bush administration, I think. And maybe that was just because it was in those conversations that it came up. Obviously, it was during the Bush administration that we had this major the torture memo that I mentioned, or what lawyers call the torture memo, right? And other obvious gigantic, the birth of Guantanamo and gigantic disputes over detainee treatment and so forth. So it came up quite often in those. One member of the Bush administration I spoke with raised it himself, actually more than one, but one in particular sticks with me. And he was at pains to talk about how he viewed the sort of permissive the path that the Bush administration took to pursue torture or enhanced interrogation techniques in the past that the Bush administration pursued over particular detention options was, in his view, a failure of lawyering. Right? He said he viewed that period of time as a case study in how lawyers shouldn't behave and how lawyering in the administration shouldn't work. That what happened was the lawyers went off in their own space or their own space, right? Their own meetings without clients present. And they clearly took as their mission maximizing presidential flexibility. And I think I showed at one point the slide about from one of these interviews. And his point, that point about flexibility, he was making in the context of a much broader conversation about they were trying to maximize flexibility for what techniques we could use in interrogation and how we could treat detainees in our custody and whether we could transfer them out of Iraq or Afghanistan or what have you. But in fact, that's not necessarily what we're looking for. And maximizing flexibility is good, but that is not remotely the only interest that we have. And it was in part this conversation that fed into one of the points that I made in the talk, which is policymakers, for a host of reasons, are not always looking for maximal flexibility. And when given it, it may create sort of biases, either cognitive biases or just process biases that tend to push it in a direction the policymakers themselves, given their own normative dispositions, wouldn't otherwise have gone.
Great. I'm going to remind people to put your questions or let me know that you've got a question into the Q&A. I'll call on you. But my other question, Deborah, is far more specific. You discussed on one of the slides Obama's decisions not to attack Syria. And there are two. One is a general involvement, and the second one is retaliation of sorts in response to their use of chemical weapons. You note, and I thought this was one of the most stunning findings, was that like 11 out of 24 said that even in situations where I think consensus of lawyers would be that you don't need to get congressional approval, authorization, if a state has attacked you, they still said that they would want to get congressional authorization.
UN Security Council authorization.
Yeah, sorry, UN Security Council.
Yeah.
But I think that in some ways that that may be because of cultural acculturation, but it could also be because they want to share responsibility. And Obama in the Syrian case may have wanted an off-ramp, but it strikes me that had he done so, that assumes that he knew what Congress would do in that particular case. So I would think that one of the ways that you could get at this with interviews is by asking people, did you think that Congress was going to give him authorization? And how serious was the effort to get that? Because to me, it may well be that Obama wanted an off-ramp. Could also be that he wanted to have shared responsibilities in case things went wrong. And it was Putin who helped Obama, got him off the hook in a sense by getting the Syrians to agree to give up at least some of the chemicals that they had.
Yeah, so great. And let me distinguish between two different things that are going on here, right? Because in every use of force, the administration has to worry about domestic legal requirements, including the Constitution, and international legal requirements, including our obligations under the UN Charter. And so those can work in different ways, and sort of the examples and the what people thought arise in different ways, right? So with respect to the Obama administration's decision to decide, I want to go seek congressional authorization for the use of force, right, post Syrian chemical weapons use, right, and that's been reported widely, and there, a lot of stories about and photographs of the famous walk on the lawn that the president goes and has and says, they seem on this is after the president has drawn this public red line: if Syria uses chemical weapons, I'm going to bomb them, and it seems like the administration is about to finally do that, and the president changes his mind against indeed some of the recommendations of some of his senior advisors. It is clear, and one or more of the folks I interviewed say that Obama said this explicitly. One quoted the president as saying in the course of this meeting, they should, with respect to Congress, they should own this, right? In other words, one of the reasons many presidents, and I think Bush would probably be included in this category, want to get congressional authorization or would like to engage Congress and would seek it if they thought they could get it, right? Or even if they thought they couldn't get it, is to share political accountability and political responsibility for what is, under any circumstances, win or lose, an enormously consequential political decision, right? So that is absolutely part of what's driving sort of policymaker interest in, gee, I want to know what all of the legal arguments are, including arguments that would favor my own normative predisposition in this case, which is that Congress should be involved in this decision-making, right? So that is absolutely at work. And that is one of many reasons why policymakers want to know what actually, right, is required, not just what's sort of maximally not required under the law. The UN Charter thing, though, that you were citing, I think that's what you're referring to from the paper, right? This is when I was asking scenarios that tried to get at what officials' normative predispositions were, right? When would you go to the UN Charter? And to the UN Security Council. And I asked them in a range of scenarios. And the range of scenarios was designed to allow me to test the extent to which their normative views matched up with a kind of conventional understanding of what the law required. So I used, for example, some scenarios in which any lawyer would say, no, you don't first have to go to the UN Security Council for authorization. That's a classic case of self-defense under international law, right? If the nation is attacked, you can attack back without waiting for UN Security Council authorization, at least, subject to some limits of the law. And a range of scenarios that were designed to test that. And what I found was that policymakers' normative predispositions about when to go to the UN Security Council didn't match up in any coherent way with the conventional understanding of what the law required. Now, why? One answer to that might be the realist view, which is they don't care about international law, they don't know what it is, and they have different reasons for thinking they want to go to the UN Security Council or not. Those reasons align with interests, not with law. But when I asked people about this, and this was one of the things we talked about most in interviews, I got a very different understanding. And the understanding was severalfold. Number one, what I mentioned before, very little knowledge of what or if the existence of UN Charter law in this space at all, right? The knowledge that there is international law here, but almost no knowledge or among relatively few officials of what exactly, even at the broadest level, it is. A second thing was a real consensus. Now, this was not uniform. This was a consensus view, right? So if I had to map the views of folks on the chart, their normative views with respect to the role of the UN Security Council on a sort of distribution chart, at the top of the curve would be the view, and this was held quite strongly by both members of Democratic administrations and Republican administrations. We should get UN Security Council authorization whenever possible. Right? That was the primary normative disposition. Why should we get UN Security Council authorization whenever possible? What is it that what interest does that serve? And most of the answers were to the effect that it is in the United States' interest to be perceived as and to act consistent with international law whenever possible. And given their lack of knowledge about what international law actually requires, it is entirely plausible that they believed, as many seemed to, that generally you have to get it all the time, right? And that, I think, now that's a long-winded answer, but I wanted to sort of flesh out what that finding was about, to why it matters, sort of what other incentives might lead officials to want to know what the law really is, because they might want to engage those processes more often than a permissive view of the law, right, might say. So if what you really want to do is maximize the role of international and domestic constraining forces, you might want to give more room for that normative disposition by policy officials to operate, as opposed to just constantly being told by lawyers, no, you don't have to do that, right? That's the idea.
That's great. I think I'm going to be able to do this. The first question comes from Luis Rodriguez, one of our fellows. And Luis, I'm going to see if I can get you, allow you to talk. I think your talking is permitted now. You can unmute yourself. And if you could introduce yourself first. And Deborah, you may want to stop the screen sharing because they'll be able to see you more effectively.
Yeah, thanks. Hold on one sec. Okay, did that do it?
Yep.
Great.
So Dr. Rodriguez.
Perfect. Let me see if you can hear me first.
Yes.
I can hear you, yes.
Okay. As Scott said, my name is Luis Rodriguez. I'm an Stanton Nuclear Security postdoctoral fellow here at CSAC. Great talk. I really enjoyed it. I have two questions. One is a follow-up to the question that Scott had, and it's about the timing of seeking counsel. The main question is, when do you see policymakers seeking counsel? As Scott was saying, there are different laws that kick in once that you declare war, and the US hasn't declared war in a long time, especially because they don't want to face its new limits or restrictions. So I wonder if different moments in a conflict also force policymakers or make policymakers ask or seek counsel. And then the second question is about the experience of policymakers in politics. As you said, things might have changed in a post-Trump era, but I wonder if outsiders, in quotation marks, behave in a similar way than politicians or policymakers that have been in politics for a long time. and if you would expect outsiders to see counsel less than seasoned politicians or policymakers. Thanks again for the great presentation.
Okay, thanks. Those are both great questions. Let me take the second one first, actually. So most of the folks in my pool, and the sort of specific numbers are in the paper, and but for the most part, the people in the pool we're talking about, and these are people who have floated to the pretty senior levels of the administration, are all people who have been around the block one way or another. I can't remember what fraction, but it might have been a third or more, maybe more, of the people I talked to has served in more than one administration or in more than one position in different administrations, right? So by the time they become, a cabinet secretary or a deputy or an undersecretary, right? They've served, or somebody at the, senior director at the NSC or more senior, they've served at the Department of Defense and the Department of State and the Department of Energy, and they were right. So across the government, I mean, not all of those, but right, multiple different positions. So the vast majority of these people, and certainly the pool of people who I spoke to directly, are people who have sort of extensive experience, right? And in part, that was one of the reasons why I was a little surprised to find the sort of relative lack of knowledge, although some people said expressly, that's why we have lawyers, right? I don't want to, and it was often hard to get them to tell me what their normative view, what do you think you should do? Notwithstanding the law. No, I'm not going to tell you what the law is, right? No, you can't consult a lawyer before you answer my question, right? They are, wow, was this steeped? Like that question was so vague. Couldn't I ask a lawyer? And can you, right? So these are repeat players by far, and because of that, it was also possible to see the extent to which, because they've interacted with counsel in different agencies, they've grown to trust them, and their repeated interactions with counsel at different agencies and over time has led to longstanding relationships in some cases, right? And yet another reason why they're willing to engage counsel so consistently. So the pool of people I'm talking to, right, in this an idiosyncratic qualitative study, although efforts to be representative, doesn't help us shed a lot of light on that. And it didn't work either to just ask, because I can tell, for example, which ones have law degrees and which ones didn't. And a fraction, of the 38 people, 16 people had law degrees. That's a lot of law degrees. But knowledge of international law in particular doesn't necessarily coordinate or correlate with having a law degree, right? International law is not required in law school and so forth. So it might well be that the state of knowledge and willingness to engage counsel even is less present in people who aren't such repeat players. But my impression is the more experience they had, the more willing and necessary they felt engagement with counsel would be. So I can't give you a great answer to that question, given the folks that I talked to. So your other question was about, when, right? So when do they actually seek counsel? So as I said in the talk, right, one person described this as lawyered up the stovepipe, right? Or one person said a triple law process, right? So from the moment, and here's where we start to get at whether I was asking about, the law regulating the conduct of wars already ongoing, or the law about the recourse to force in the first instance, really matters. So in wars already ongoing, right, there is so much lawyering that happens, right? Then I would be talking to commanders and lawyers on the battlefield, right? And have. So when I teach contemporary conflicts or national security law at law school, I'll bring in, for example, one of the guys I had in from SEAL Team 6 to tell me, right, how his decision-making process worked. And he'd say, we were dug into the trench and it's me here and I've got on the phone my lawyer, right? Now, this is in that case, a JAG lawyer and whatever. And we're talking about particular targeting rules. We're not talking about the UN charter scheme, right? We're talking about, is this a civilian? Is this a combatant? Can I take this shot? Can I not take this shot? Right? So different laws that are applying, but an even more intensive engagement of lawyers at the sort of most immediate level. And there are reasons for that. And some of the reasons are sort of culture and habit and bureaucracy and so forth. But one of the reasons we would be remiss if we didn't mention was the existence of a highly developed criminal penal system that applies to members of the military and the people who are making decisions about uses of force in wars already ongoing, that if they make the wrong decision or an illegal decision about a target, right, they can be subject not only to domestic criminal punishment under the Uniform Code of Military Justice, but they can be subject to war crimes liability in foreign courts and maybe international courts, but foreign courts at a minimum, where jurisdiction can be had for universal offenses. So there are some serious offenses serious incentives that operate at that level. Indeed, for every member of the military up to the Joint Chiefs level, right? Any serving member of the military is subject to that code of law, that don't operate in the civilian policy space. And that was one of the reasons I thought it was important to talk to civilian and not military officials. So when did these senior policymakers talk to lawyers? By their account, all the time, right? One used the word constant. One describing Obama administration principals meetings said, I can't remember a principals meeting in which I was present in which the president didn't at one point turn to his lawyer. Now that was either, White House counsel or sometimes NSC general counsel. It was a different, depending on the lawyer, but a lawyer at the senior level. And these are legal questions that have been, as the previous, interview that I described, and consistently they all said, right, have already been lawyered one way or another up the stovepipe, right? So especially with wars that are still ongoing, but in which there may not be a congressional declaration of war, but there is a gigantic federal law called the Authorization for the Use of Military Force that is a matter of domestic law, regulates the ongoing conduct of the war against Al-Qaeda and associated forces and everybody else, right? So they are there all the time, and whether the idea originates at the agency level, right, in DOD or in one of the combatant command areas, or whether the idea originates in the NSC, right, the lawyers are just there all the time. These people are friends, they're on the same team, they're in the same meetings, they are never not there. So I think that's about as good as I can do in answering that question.
That's great. Thank you. Sigrid Lupieri, you're next up. Let me unmute you. There, hold on. You should be unmuted now.
Yes, I think you can hear me now.
Yes.
Yes, I can. Yeah.
Yeah. And introduce yourself.
Yes. So I am Sigrid Lupieri. I'm a postdoctoral fellow here at CSAC. And thank you so much for this really interesting talk. I was curious to hear a little bit more. I'm not sure if this is something that came out in your interviews, but how the decision-making processes apply more specifically to discussions around humanitarian interventions. And if you see any changes over time among these processes, among policymakers, for example, after 2005, with the emergence of the principle of the responsibility to protect, and if this has any bearing on your findings at all.
Yeah, so that's a really good question. And I should say, right, and there's a lot to be said about what the law says about our responsibility to protect and so forth. But I should say the Syria example is actually a pretty good example, right? A lot of for talking about intervention for humanitarian purposes, right? A lot of the concern in Syria, a huge amount of the concern in Syria, up to and including the use of chemical weapons, was about the humanitarian impact of what the Syrian regime was doing. So it was not only the use of chemical weapons, but also the massive bombing of civilians, the torture of detainees, the massive outflow of refugees and displacement of persons, right, that was creating this catastrophic situation on the ground in Syria, and a great deal of the pressure that that existed domestically and internationally against the administration to do something came from concerns about the humanitarian situation in Syria. So that might be a fine example to say that when I said, and this was certainly true, and of the interviews I quoted about the lawyers could never get to a position where they thought this was legal, right? That is an unsurprising position for lawyers to take, right? So the US government does not embrace the view that international law requires the use of force for the purposes of humanitarian intervention, right? The closest that the United States came to saying we can do this notwithstanding international law that says there are only 3 circumstances when you can use force, and humanitarian intervention isn't one of them, right? What the conventional view is, international law says that there's the UN Charter provision that I quoted, right? No use of force against the sovereign territory of another state unless that state consents, the victim state is acting in self-defense, right? Or there is a UN Security Council authorization, right? And that is the sort of most broadly accepted sort of conventional view of what the UN Charter scheme requires. There are some lawyers and some states that think that humanitarian intervention is an exception to this. And the United States came closest to this view in Kosovo in a memo produced by the Clinton Office of Legal Counsel, in which it said, right, we're going to do this because in Kosovo, because, we have to do this. And we think it is consistent with the president's domestic constitutional authority to do this, right? But the most that the international community ever said about the Kosovo intervention, or the closest it came to saying it was legal, was to say that this was illegal, but legitimate nonetheless, because there had been such an international consensus. The United States and its NATO allies had acted after exhausting every other conceivable means for resolving the conflict and diplomatic measures and so forth. And because it acted in concert with international allies, and because after the fact, the UN Security Council declined to condemn NATO intervention in Kosovo. So our lawyers, US lawyers, the US administration are far from forward-leaning on that question. And that has been the case across Democratic and Republican administrations as well. There is no recognition of an obligation to intervene. And in fact, most of the concern is to do with, even if we wanted to intervene, how do we get past what remains the kind of standard conventional understanding, which is that absent UN Security Council authorization, you can't. I don't know if that gets at what you were asking, but.
Absolutely. Thank you so much.
Yeah.
So we have a question from Len Weiss. Len, why don't you tell Deborah a little bit about your background? And I think I made it so that you can talk now. But we can't hear you. Are you muted?
Can you hear me now?
Yes.
Yes.
Okay. You want to know something about my background? All right. I worked in the U.S. Senate for about 23 years on various issues, many of them nuclear related or safety related with respect to nuclear technology. And I was involved in looking at the programs of various countries that were were interested in making nuclear weapons, like India and Pakistan and so forth.
Now in his retirement, he's an affiliate here at CSAC. So
that's correct.
So Len, what's your question?
Oh, I wrote it. I guess. All right. The question was this: I was wondering whether in the interviews you had with all those lawyers, whether the question of the assassination of Anwar al-Awlaki came up, because it's been it's a controversial issue where an American citizen was ordered to be assassinated by the president. And it seems to me that that's a major issue for a group of lawyers to discuss who are interested in what U.S. policy should be abroad?
Thanks. Yeah. So again, right, for this particular study, and the 38 people I'm talking about, right, these are specifically not lawyers that I'm talking to, but I did separately, and I wouldn't describe it as part of any sort of systematic study, but I talked to an awful lot of lawyers who were involved in this decision making. So I can tell you at least two things about that, right? So the legal argument that the Obama administration lawyers made that this was lawful was that they're under both domestic and international law, right? Let me start with domestic, was that the source of domestic authority is the authorization for the use of military force, a statute passed by Congress weeks after 9/11, still on the books today, that authorizes the president to use all necessary and appropriate force against those nations, organizations, or persons he determines are responsible for the attacks of 9/11. So courts and administrations consecutively have read this to apply to, at a minimum, al-Qaeda, the Taliban, and associated forces, and then later in the Obama years, ISIS as well, right? So al-Awlaki in the Obama administration was understood, and the public reports allegations were that he was a member of al-Qaeda, and not only was he a member of al-Qaeda, that he was engaged in operational planning and efforts to carry out operations on behalf of al-Qaeda. Right. So yes, an American citizen, but a member of al-Qaeda living abroad and engaged in active, operational planning for the attack. And lawyers are quick to say, and folks who've written about this in sort of memoir space have said, we didn't start thinking about actually going after al-Awlaki until he, as they put it, went operational in this regard. Right. So as a matter of domestic law, they would say the president has the authority to use force, actual force. Right. This is not an assassination. This is part of a military campaign against al-Awlaki, just like any other member of al-Qaeda on the battlefield in Afghanistan or anywhere else, right? That's the domestic source of authority, they would say. And as a matter of international law, right, the United States was engaged in an ongoing non-international armed conflict, so an armed conflict within the meaning of the Geneva Conventions that was justified in the first instance by, in the sort of recourse to force context, by a self-defensive use of force by the United States following the attacks of 9/11, and that was justified ongoing under the Geneva Conventions because this person was in a non-state actor way, a combatant, a permissible target in the course of an armed conflict, like a combatant, without getting into too much detail, right? So the lawyers said, right, would say, same thing goes. And indeed, the Supreme Court in 2004 said, you can detain American citizens picked up on the battlefield in Afghanistan under the authorization for the use of military force as a matter of domestic law, even though they are American citizens, right? Provided that you comply with a whole bunch of procedural requirements and so forth. So they would say, right, there was legal justification. The critique of this, and it gets long, but let me just a few, would be to say, you got to that understanding only by, particularly on international law, an enormously expansive understanding of what counts as an armed conflict under international law. And when I say, implausibly broad, in 20 years post 9/11, no other country in the world has accepted, even our closest allies, right, the breadth of the United States understanding of the scope of the armed conflict. But nonetheless, it is not what I would call an unethically broad legal argument. It is just maximally broad understanding of the scope of sort of legal permissiveness under international law. And that came out of the legal counsel system that is the one I was studying here.
I have a question that is not about your study. It's about how you're thinking about the role of law. I found it very refreshing that your conclusions include a lot of cautionary notes about lawyers can be permissive, not just constraining, and we have to be worried about people going foreign shopping, trying to find the lawyer that will defend their position if we have more lawyers. And it's good to have a lawyer who's aware of those issues. In January this year, we had a remarkable legal conundrum happen where the chairman of the Joint Chiefs reportedly pulled a Schlesinger, what he called a reference to James Schlesinger, warning people during the Nixon administration to contact him if Nixon ordered the use of force. And General Miley reportedly told combatant commanders that I'm not in the chain of command, I am in the chain of communications, and I want you to communicate to me if you get any orders about the use of force. And some people were concerned about nuclear, other people were concerned just about something going on with China. How do you think about that? On the one hand, that strikes me as a extra constitutional act. On the other hand, I'm really glad he did it. So how should we think? Walk us through that. How should we think about the chairman of the Joint Chiefs pulling a Schlesinger?
Yeah. So, God, there's a lot in there. And it's a great question and a complicated question. So let me, I guess, just say a few things. Number one, on those particular facts, right, it's not at all clear to me that he did anything unconstitutional, certainly anything unconstitutional or even illegal, right? The worry in that context is about much broader questions, not necessarily legal questions, but really, really important policy and institutional questions about civil military relations and civilian control. Now, this is a topic about which I've written a separate paper called The Soldier, the State, and the Separation of Powers, in which I argue that standard political science theories of what civilian control means actually bear no relationship to what the Constitution says it means, so or should mean. So that's maybe a discussion for a different time. But the worry is this, and it arose in the torture context as well, right? The worry is you have military, members of the uniformed military who are supposed to be, and are as a matter of law in lots of different ways, under the command of civilian authorities for lots of really important reasons in our democracy, themselves acting as a constraint on the power of a runaway civilian executive, right? But here, I think it's incredibly important to distinguish between stupid civilians or misguided civilians or wrong-headed civilians, right? And civilians that are contemplating actions that are illegal, right? When the military acts to constrain or attempts to constrain a civilian leader because they think he's making a boneheaded decision, right? And that happens all the time too, right? That's problematic because then it really is just the power of this enormous bureaucratic structure and its ability to constrain or interfere with the proper operation of civilian authorities, okay? But when the military is acting as a constraint for the purpose of and with a view to giving effect to other existing legal obligations of the civilian executive, right? This was the case in the role of the JAG lawyers pushing back enormously against the civilian leadership of the Bush administration that said, yes, let's go engage in torture and other enhanced interrogation techniques, which was the term that they used at the time. Right? This isn't the JAG lawyers, the military trying to constrain the civilian executive without civilian authority. This is the military trying to give effect to laws enacted by the civilian Congress and treaties ratified by the civilian Senate that say, thou shalt not torture. Right? So it is pitting one civilian branch, right, against another. And in fact, the civilian branch that holds the legal writing pen, right? So in that case, and I would argue, although I don't know all the details, I don't know if any of us know all the details about the particular Millie Trump example, right? That some of the things they were probably worried about Trump doing were illegal and not, were both boneheaded and illegal, right? So to the extent what they were worried about was giving effect to, and they have legal obligations not to follow manifestly unlawful orders, right?
Correct.
The law requires them not to do that. To the extent that that's what they were worried about, you're gonna, right, start a war without any congressional authorization, even in a way that OLC wouldn't justify, right? That's the kind of thing that I think is an appropriate role for the military to play, a role that we want them to play. Now, where it gets into interfering with boneheaded decisions, tragically, that's a much more complicated area.
It is, and it seems to me that you know, a secretary or a chairman under those conditions would have only to resort to saying that I think the decision is being made by an incapacitated individual, and we therefore want to invoke the 25th. It would be
Well,
very
you could,
hard.
I mean, the military can't invoke the 25th Amendment on its
The
own.
military could go to the Secretary of Defense and say, I think that the orders that are coming forward are reflecting a deranged individual, and that I am not going to follow them until I have your view of what the cabinet thinks about the 25th Amendment.
So they can say that, right? But ultimately, to deprive the president of operational legal authority, it requires not only it requires a vote of 2/3 of the cabinet.
Right.
Right. That's a high bar.
It's a very high bar, and you know, fortunately, we have never had to have that. But I think what my understanding is what Miley was doing was giving some warnings to people out in the field that I'm really worried about what's happening here.
Absolutely. Yeah, no doubt. Or I agree.
Well, we'll have to have you back to talk about that other paper, because that sounds fascinating as well. But I hope that everybody on the Zoom call will join me in thanking Deborah Perlstein for a fantastic talk today. Thank you so much.
Thanks very much. Thanks a lot for having me, Scott, and nice to chat with you all.